All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated, veuillez vous asseoir.
Good morning, everyone. Is the mic on? Yes. Good morning, everyone. Madam Court Officer, can you please mention the case?
Good morning, Madam President. This is the situation in the Republic of Kenya in the case of the prosecutor versus Paul Gicheru, case reference ICC 0109-0120, and for the record, we're in open session.
Thank you very much. Can I ask the parties to introduce themselves, starting with the prosecution?
Good morning, Your Honor. Good morning, everyone. My name is Anton Steinberg, appearing for the prosecution today. With me, trial lawyer Elice Zago, associate trial lawyers Julia Spiesberger, Laura Warlich, Inbal Jalowski, associate legal officer Mariana Gutierrez, case manager Grace Go, and intern Ozan Ozturk. Thank you.
Thank you very much, Mr. Steinberg. Mr. Canavas for the defense, please.
Good morning, Your Honor, and good morning to everyone in and around the courtroom. I'm with Ms. Susanna Tomanovich, Noah Elmont, Daria Machete, and Victoria Amanlanier.
Thank you very much, Mr. Canavas. And for the records, I note that the accused, Mr. Gicheru, is joining us via video link. A very good morning to you, Mr. Gicheru.
Good morning, Madam President.
Thank you very much. We are now hearing the closing statements of the parties in these proceedings. As stated in decision number 329, each party has been allotted 1 hour, and we'll start by hearing the statement of the prosecution. In between, after the prosecution would have done his statement, Mr. Canavas will observe a 5-minute break and come back. But I'll ask all parties to stay in court, so it will be a short one. Mr. Prosecutor, the floor is yours, please.
I'm grateful, Your Honor. Your Honor, the prosecution's closing brief sets out in detail how the evidence presented proves beyond reasonable doubt Paul Gicheru's guilt on all 8 counts of corrupt influencing of prosecution witnesses. This evidence stands uncontroverted by any defense witnesses. As instructed by the Chamber, the prosecution will not repeat the submissions in its closing brief, but rather focus on responding to the defense's arguments and case theory to the extent that the latter can be discerned from the defense brief. Your Honor, the defense brief adopts a flawed approach to the assessment of evidence. It indulges in a piecemeal examination of individual witnesses and documents, but ignores the combined effect of the damning and mutually corroborating body of incriminating evidence. Stripped of its rhetoric and hyperbole, the defense brief essentially invites the Chamber to 1. Reject prosecution witnesses' evidence in totality on the basis of exaggerated past credibility issues. 2. To ignore a significant body of corroborating evidence. And 3. To buy into speculative conspiracy theories unsupported by any acceptable evidence. Finally, the defense brief deflects from the real issues by raising imaginary or irrelevant criticisms of the prosecution's investigation and witness preparation sessions. However, none of this detracts from the compelling evidence that is before the Chamber. In sum, the defense criticisms may be grouped under several well-worn defense tropes. 1. The prosecution witnesses are liars. 2. My client was framed. 3. It's all a conspiracy. And 4. If only the prosecution had or had not done X, Y, or Z, then my client's innocence would have been revealed. None of these arguments, Your Honor, disturb the conclusion that the prosecution has proved its case beyond reasonable doubt. I do not propose to respond to the defense's arguments on the individual witnesses, charges, or modes of liability, since these have already been addressed in detail in the prosecution's closing brief. Nor will I respond to the intemperate language of the defense brief, other than to observe that the tone of the rhetoric is often inversely proportional to the substance of the submissions. Rather, I will address certain themes raised in the defense brief and the logical and evidential flaws in the defense's theory. At the outset, however, it bears repeating that the chamber is essentially faced with a binary choice. Either the witnesses and evidence presented by the prosecution are true and correct in their essential features, and Mr. Gicheru is indeed guilty as charged, or else he has been the victim of a grand conspiracy of breathtaking scope, intricacy, and duration. There is no middle ground. There is no innocent explanation consistent with the prosecution's evidence, and none has been suggested by the defense. If the chamber accepts the prosecution evidence, it must return a verdict of guilty on all 8 counts of corrupt influence, contrary to Article 71C of the statute. Before proceeding further, however, I'd like to propose that rather than reading all of the references to the briefs and to underlying evidence in full, with the leave of the chamber and the permission of my learned friend, I've provided copies of my reading notes to the chamber that contain the complete references.
Thank you.
I will not have to tax the transcribers then with that. I'd like to start, Your Honor, by making a few submissions on the defense's legal approach to the assessment of evidence and the standard of proof. Starting with the defense approach to the standard of proof, the defense statement of the beyond reasonable doubt standard is by and large correct, Your Honor, but it introduces an element of imprecision by the insertion of the word material in its recap of the appeals chamber's dictum in the Bemba appeal. This reads in its original form as follows, quote, "The trial chamber is required to make findings of fact to the standard of proof beyond reasonable doubt only in relation to those facts and not those material facts as stated by the defense, only in relation to those facts that correspond to the elements of crimes and modes of liability of the accused as charged." Why is this significant, Your Honor? It is because the term material facts is commonly used in a broader sense to refer to those facts that the prosecution must plead in its DCC in order to give the defense sufficient notice of the case that it intends to present. But such material facts may extend beyond the essential facts necessary to prove elements of the offense and the applicable modes of liability. Prosecution submission, Your Honor, is that the jurisprudence of the court makes it clear that it's only the latter facts and not the former that must be proved beyond reasonable doubt. For this reason, the prosecution submits that the formulation at paragraph 15 of the prosecution's closing brief is a more accurate expression of the law. Turning to the issue of inferential reasoning, once again, the defense's formulation for the test for inferential reasoning is also correct, but only insofar as the fact sought to be inferred is a fact requiring proof beyond reasonable doubt, as just discussed. It follows that not every underlying or intermediate fact needs to be proved beyond reasonable doubt, and for this reason, such facts do not have to meet the inferential reasoning test outlined by the defense. I refer in this regard to paragraphs 15 and footnote 30 of the prosecution's closing brief. As previously mentioned, the defense adopts a piecemeal approach to the assessment of evidence. While the defense brief pays lip service to the need for an holistic assessment of evidence, in practice it does the opposite. Each witness and each piece of evidence is assessed in isolation, declared unreliable or incapable of belief, and then rejected outright. When addressing corroboration, other evidence deemed unacceptable through the same myopic approach is simply ignored. At no point does the defense step back and assess the impact of the evidence in its totality. However, Your Honor, this is precisely how a court should not go about assessing evidence. To the contrary, the prosecution submits that the Chamber should be guided in its assessment of the evidence by the principles established in the consistent body of jurisprudence of this court, as set out in Section A1 of the prosecution closing brief, which I will not repeat. Turning to the defense's use of the term hearsay, Your Honor, the defense brief frequently attacks the prosecution evidence as hearsay and invites the Chamber to reject it on this basis. In fact, the word hearsay is mentioned no fewer than 123 times in the defense brief. However, aside from the fact that hearsay evidence is not inadmissible at this court, the term is often applied to evidence that is not in fact hearsay at all. So, for instance, the brief describes as hearsay P397's evidence regarding his meetings and interactions with the accused. But in fact, P397 provides an account of evidence that he personally witnessed and experienced, which is, in truth, direct evidence. It is, of course, the case that P397 is unavailable to testify for reasons which have been well ventilated before this court. And the prosecution is thus constrained to rely on his prior recorded testimony under Rule 68(1)(c). I'm being told to slow down. But that, of course, is an entirely different issue, and one that the Chamber will consider in determining the weight of this evidence. However, as set out in detail in the prosecution's closing brief, P397's evidence is credible, consistent, and corroborated in its essential features, and should be accepted by the Chamber. In weighing the reliability of the evidence, Your Honor, the Chamber should also take into account the accused's false denial of his relationship with P397, a point to which I will return presently. The defense also dismisses as hearsay the recordings and evidence of witnesses concerning their conversations with intermediaries and associates, when in truth only a small portion of these conversations can properly be labeled as hearsay. For instance, at paragraph 87 of the defense brief, B800's evidence that Barassa called him and stated that he, Barassa, had accepted a bribe and asked P800 to do the same is referred to as hearsay. But this is in fact direct evidence of these events. And the fact that this conversation was not recorded does not make it hearsay. By the same token, the various statements of intermediaries and associates aimed at corruptly influencing the witnesses constitutes direct evidence of the actus reus of corrupt influence. And evidence of intermediaries persuading the witnesses who agreed to withdraw to come back to Kenya and to meet with Mr. Gicheru provides direct evidence of the existence and operation of the common plan. Only in those few narrow instances where the perpetrators state that Mr. Gicheru did X or said Y can the evidence properly be labeled as hearsay. But, Your Honor, even then the Chamber may rely on this evidence. The Appeals Chamber, in the Bemba et al. Appeal, rejected defense arguments that the trial chamber had erred in relying on remote and untested hearsay in the form of intercepted communications. The Appeals Chamber found that the interaction between other members of the common plan that was reflected in the intercepted communications, quote, shows that Mr. Bemba's co-perpetrators acted under the common understanding that Mr. Bemba was involved in the scheme of illicit witness coaching and gave instructions regarding the expected testimony, unquote. So too in the present case, the OPC recordings demonstrate that Barassa, Bet, Yebe, and P495 all acted with the common understanding that Mr. Gicheru was the person to whom targeted witnesses were to be brought to negotiate and receive their bribes. So I invite the Chamber to examine critically the defense's assertions regarding hearsay evidence. But to the extent that certain evidence may be correctly labeled as hearsay, it may still, where appropriate, be relied upon by the Chamber, as set out in the prosecution's closing brief. Particularly, Your Honour, for corroboration or to establish peripheral or intermediate facts not requiring proof beyond reasonable doubt. I move on then, Your Honour, to the defence's approach to the credibility of prosecution witnesses. It is no surprise that certain prosecution witnesses had credibility issues and had at some point told lies, including under oath. This is, after all, a corruption case. Prosecution witnesses were bribed and intimidated into agreeing to sign recanting affidavits, making fabricated allegations against the prosecution and other witnesses, and to provide false evidence in the Ruto and Sang case. It is for this very reason that the prosecution went to such great lengths to obtain objective corroboration for the witnesses' evidence, such as recording of approaches by perpetrators, bank records, communication data, and so forth, as explained by lead investigator P730. For the most part, the corrupted witnesses readily admitted those lies once the influence of the accused and associates was removed. However, the corrosive effects of corrupt influence was more pervasive in others, and some witnesses were, unsurprisingly, embarrassed or scared to admit the full extent of their wrongdoing. So, for instance, P800 was initially reluctant to implicate his friend as the person who took him to meet the accused, but later came clean as trust was established. And while P516 admitted very reluctantly to receiving payments from Mr. Gicheru to withdraw as a prosecution witness, he steadfastly refused to concede that he had lied in other aspects of his evidence in the Ruto and Sang case. The defense relies on these and other credibility issues, real or imagined, to argue that the evidence of all the prosecution fact witnesses, excluding P738, must be rejected lock, stock, and barrel. However, this approach ignores the jurisprudence of the Bemba et al. Trial chamber, confirmed on appeal, that, quote, no witness is per se unreliable, including a witness that has previously given false testimony before a court. Instead, each statement made by a witness must be assessed individually. The testimony of one and the same witness may therefore be reliable in one part, but not reliable in another. While the testimony of such witnesses should be approached with caution, and the presence or absence of corroboration will be an important consideration, a far more nuanced and reasoned analysis of the witness's testimony than that performed by the defense is required, particularly in a case of this nature. Ultimately, the question that the chamber must answer is not whether or not the witnesses have lied in the past, but whether or not they were lying when they testified before this chamber, that they were corruptly influenced by the accused and his associates. Although I promised not to react to the criticism of each witness, I am constrained to observe that many of the defense's criticisms of the witnesses' testimonies before this chamber are based on exaggerated or imagined inconsistencies, which are then characterized as, quote, lies under oath, unquote. So, for instance, the defense incorrectly claims at paragraph 61 of the brief and footnote 356 that P613, quote, testified that she lied to the VWU because she was bored and lonely, unquote. However, an examination of the testimony cited reveals that she made no such admission. Similarly, the defense accuses P800 of lying under oath about whether or not he was permitted to contact other OTP witnesses. based on a supposed contradiction between pages 33 and 53 of transcript 52. But this is based on a misinterpretation, or at best selective interpretation, of his evidence. The defense claims at paragraph 80 of their brief that P800 testified that he was, quote, permitted, unquote, to contact other witnesses. What the witness actually said was, quote, I explained that due to the fact that we were coming from the same and we knew where we were, at times we could speak without permission, unquote. We could speak without permission. In context, what the witness was saying, I submit, is that they would sometimes speak to other witnesses despite not having permission, but he did not claim that he was actually permitted to do so. These are but two examples, and I invite the Chamber to examine, for instance, the defense's claims at paragraph 150, footnotes 882 to 885, and paragraph 115, footnotes 673 to 674. Your Honor, many other assertions by the defense brief are also based on strained or cynical interpretations of the evidence, but I trust the Chamber will draw its own conclusions when reviewing the underlying material. I move on now to the issue of corroborating evidence. The defense attacks the items of corroborative evidence relied on by the prosecution on an individual basis, but fails to consider the holistic effect of this evidence. So the defense points out correctly that the bank records of 397 and 341 do not in themselves prove conclusively that the source of the huge cash deposits was the accused. But the defense fails to consider that the mere fact that not just one, but two of the corrupted witnesses both came into huge amounts of money, way beyond their previous means, at the precise time they were allegedly being targeted by the accused and his associates, has in itself significant corroborative value. I digress to point out, however, that the very reason why the witnesses were all paid in cash was precisely to avoid leaving a paper trail connecting them to Mr. Gicheru. This was explained to the witnesses by the accused himself, as well as his associates. And I refer, Your Honor, to the references in footnote 190 of the prosecution's trial brief. The defense's alternative theories for these deposits are entirely speculative. The defense hypothesizes that P397's deposits might have been the proceeds from the sale of a plot of land. But the only evidence of this, in the form of an investigation report, reveals that as of 7 May 2013, P397 had not yet found a buyer for his farm. This is a week after the money was deposited in his account. And as regards P341, the defense simply speculates that he might have sold property or acquired money from his 25 dependents, unquote. Apart from the fact that one does not normally receive money from dependents, it's normally the other way around, of course, but there's no evidential basis whatsoever for this assumption. Regarding the defense's criticism of the reliability of the bank records, there are ample indicia of reliability for both documents. And P397's deposits are also confirmed by contemporaneous SMS alerts from the bank, as is revealed in his telephone data. The fact that P341 did not bring his bank statements in a sealed envelope with a business card attached does not make them suspect, Your Honor, as claimed by the defense. These bank statements bear the witness's name, the official stamp of the bank, and the signature of the branch manager on each page. The statement is entirely regular on its face, and there are no indications whatsoever of any tampering or manipulation, nor has the defense identified any. Furthermore, as to the defense's criticism that the witness bank card number does not match the account number, there is no evidence to suggest that these numbers are necessarily the same, especially in Kenya. Turning then to the telephone data produced by the prosecution. The defense argues that this does not establish conclusively that the accused was in contact at the relevant time with the relevant persons. Again, while this is correct, the defense does not consider the implication of the fact that the accused, a person whom they say is allegedly selected at random to be the scapegoat of some grand conspiracy, is positively connected through the phone data to almost every significant actor implicated by the witnesses as participating in the witness corruption scheme. Remember, Your Honor, that it is undisputed that the witnesses did not know Mr. Gicheru and had no dealings with him prior to these events, with the exception of P397, whose allegations of relationship the accused made I will discuss shortly. However, how could these witnesses possibly have known in 2013 what the phone data would subsequently reveal in 2021? Was it just dumb luck? Now, one or two overlaps between the persons implicated by the witnesses and the phone data might be dismissed as a coincidence. But there are no fewer than 10 common plan members and associates and other persons of interest linked to the accused by the phone data. This includes managers Simatwo and Mayo, intermediaries Barasa and Bet, associates Busanei, P495 and Kogo, as well as lawyers Njuguna and Mite, and of course the ultimate beneficiary of the scheme, Mr. William Ruto. I note in this regard that the defense brief mistakenly alleges that the relevant contact details for Ruto were not contained in the phone data. And this is at paragraph 188 of the defense brief and footnote 1018. However, this is incorrect, Your Honor. Proper inspection of the record reveals that the number is in fact reflected in the records, and I refer the Chamber to Ken OTP 01600043 at items 1766 to 1767. I invite my learned friend to withdraw that assertion. I must also respond to another repeated assertion in the defense brief concerning the telephone data. But I will have to do so in somewhat oblique terms since we are in public session. And that is the allegation that information establishing the connection between the accused and the relevant persons I have just listed was, quote, inserted, unquote, in 2018. The implication being, I presume, that it did not exist prior to that. However, closer inspection, I beg your pardon, will reveal that all the relevant data was created on exactly the same day at precisely the same time, give or take 1 minute. To be precise, 6 October 2018, between 0726 and 0727 Universal Time. And not only those numbers, but hundreds of others too. It would be physically impossible to have inserted all these numbers manually. And this can only have been inserted through importing the data from another device or a backup. So while the initial date of creation of the various entries cannot be determined from the phone data, it was clearly not created for the first time on this date and must have existed previously. This is also consistent with the report of the Forensic Science section, admitted under Rule 68.2b, which concludes that the data in its present location was uploaded through restoring a previous backup. I turn then to the OPC recordings, one-party consent recordings. The defense has to date failed to provide any consistent or coherent theory explaining the OPC recording evidence. Perhaps my learned friend will finally provide an explanation today for the first time, in which case I may be forced to seek leave to reply. The prosecution has disclosed to the defense no fewer than 117 different recorded conversations, 97 of which have been submitted into the record, together with their relevant transcriptions and translations. These conversations were recorded by P738, P613, P800, P495, and P397 respectively, from May 2013 to July 2014, and involve intermediaries and associates Yabe, Barasa, Bet, P495, and the accused himself. If accepted, this body of evidence provides cogent proof of the existence and modus operandi of the witness interference scheme and the accused's participation and role therein. It also strongly corroborates the evidence of prosecution witnesses to this effect. Against this background, the defense neglects to address the OPC recordings as a body of evidence in its closing brief. However, as best as can be gleaned from the defense's cross-examination and from its analysis of the evidence of the prosecution witnesses, it appears to suggest that all of these recordings were pre-scripted by one or more of the prosecution witnesses with the agreement and cooperation of the persons being recorded. The alleged purpose, it seems, was to create false evidence in support of bogus claims of witness interference in order to receive witness protection and the attendant benefits. And for some reason, which is yet unexplained, they decided to inject the accused's name into their false narrative as the guiding hand behind the witness interference scheme. Excuse me. Apart from the fact that there is not a shred of acceptable evidence of any such agreement, this simply does not gel with the contents and tone of these recorded conversations. Some of the recordings concern mundane matters or logistical arrangements for proposed meetings, including some meetings that never happened. Associates clearly speak in guarded or coded languages and sometimes express reluctance to discuss matters on the phone. Your Honor, had the purpose been to manufacture evidence to implicate Mr. Gicheru as the person behind it, one would have expected to see a far more clear, explicit, and polished narrative and much less irrelevant chit-chat. And this purpose could have been served in one or two short and clear meetings without going to the extent of arranging face-to-face meetings. In contrast, Your Honor, the interlocutors are quite careful for the most part not to mention Mr. Gicheru's name on the phone, even though it is clear from the language and context that they are referring to him. The most explicit discussions of Mr. Gicheru's involvement and role are largely reserved for the face-to-face meetings with Barasa and 495, respectively, when presumably they thought they were safe from interception. It is also inconceivable, Your Honor, that the intermediaries and associates would deliberately incriminate themselves on record of serious criminal offenses simply for the benefit of the prosecution witnesses. And in the case of Barasa and P495, knowing that they had been recorded offering bribes to OTP witnesses and that these conversations would be handed to the investigators, it is absurd to suggest that they would then travel outside Kenya to meet with the witnesses and deliberately expose themselves to arrest. And what of the OPC recordings between Barasa and P738? The defense has not suggested that this witness was involved in any conspiracy to falsely implicate the accused or to falsify evidence, and her credibility stands entirely unimpeached. She was not even cross-examined. How are these calls to be explained, other than what they clearly are? An increasingly desperate effort by Barasa to corruptly influence the witness to return to Kenya and meet with Gicheru to receive her payments before leaving for The Hague to testify. Your Honour, this speculative theory simply defies all logic and belief and should be rejected by the Chamber as a reasonable possibility. Excuse me. I turn then to the recorded call between P397 and the accused. The defence's explanation for the accused's recorded conversation with P397 is strained and inconsistent with the contents and context of the calls. The defense asserts that, in the face of statements by P397 regarding the accused's involvement in his withdrawal as a prosecution witness, the accused was, quote, non-responsive, unquote. As I will shortly demonstrate, this is not entirely correct. But even to the extent that it is, this is in itself significant. Unresponsiveness in circumstances where a response would be expected from an innocent person may be incriminating per se, particularly in the absence of any reasonable explanation. As a lawyer himself, the accused would have been well aware of this. So when the witness says to the accused, quote, "Please figure out how you're going to help me, because I agreed to withdraw from the ICC. Now I'm in your hands," unquote. The obvious response would be, "What do you mean you agreed to withdraw from the ICC? What does this have to do with me?" And this is particularly significant, Your Honour, since in his interview under caution, Mr. Gicheru denied knowing that P397 was in fact an ICC witness. If that were indeed true, I submit that it is inconceivable that this revelation would not prompt a response. Instead, the accused deflects by saying, quote, "You know, when those people do their stupidity like that," and then trails off, unquote. However, on another occasion, the defense does respond, and its responses are significant. When P397 says to the accused explicitly, quote, "You are the one who had me return to you, and you persuaded me. We spoke to you together with Silas Amatwa. You told me, 'My dear, you are one of our people. I've come to you, and now you start putting me in the bush again,' unquote. Again, no indignant denial or surprised query. Rather, on this occasion, the accused's response is to object that the witness has mentioned his name on the telephone and that of Samatwa. And when the witness complains that Samatwa has been avoiding him, Gicheru replies, quote, "I don't know where he is. You know, I even planned things without talking to him for a while," unquote. So what are these things that Mr. Gicheru was planning together with Samatwa? In the absence of any reasonable explanation from the accused, the only inference consistent with the evidence is that he was talking about the witness interference scheme. Finally, when the witness is questioned if perhaps he, quote, "wronged Gicheru's office somehow," unquote, and offers to refund the money, Mr. Gicheru simply says, "Stop." Not "what money? What are you talking about?" Just stop. Your Honor, the only person who would be able to provide an explanation for these highly incriminating responses is the accused. He was unable to do so in his interview under caution, and he has chosen not to do so in this trial, as this is right, but the questions remain unanswered. The defense brief doesn't even attempt to grapple with this evidence. Instead, it complains that P397's conversation was, quote, "scripted," unquote. Apart from being inaccurate, as the verbatim record of the interview will attest, the obvious response is, so what? What would it matter if P397's words were entirely scripted? What is important, Your Honor, is the accused's response, or lack thereof, as the case may be. No objection was raised by the defense on this basis at the time the evidence was submitted, and none is raised now. Rather, the defense again deflects with red herrings, hinting darkly at prosecutorial misconduct, but failing to point out any specific consequences or request any remedy, a theme which permeates the defense brief. I move on now to the accused's interview under caution. The brief also does not address the significant admissions made by the accused during his interview with the OTP. In particular, his transparent and evolving lies concerning his relationship with P397 and Yabe. Although the defense adopts the accused's ultimate version that he represented P397 in a land transaction, it does not acknowledge the fact that the accused initially categorically denied knowing him. Then, when confronted with the recorded conversations with P397, the accused at first claimed that he could not recognize his own voice. He then conceded that it must have been someone he was familiar with and that perhaps he was a client, but he would need to check his office records. Subsequently, the accused stated that he recalled the threats P397 had received and remembered calling Busonei on his behalf. Finally, he came up with the version that he had acted for P397 in a land matter and gave ever more detailed descriptions of the transaction. All the references, Your Honor, are in the speaking notes. Your Honor, the accused also admitted having read about P397's disappearance in the newspapers, despite previously claiming that he did not read the newspapers when asked about Yabe's disappearance. While the defense now wants the chamber to accept the accused's final version that P397 was a legitimate client, it failed to produce any of the records Mr. Gicheru claimed to have at his office, which could easily have established a genuine attorney-client relationship if this were true. Land transactions typically produce lots of paper, in my experience. Your Honor, I submit that the accused's evasiveness and dissembling concerning his relationship with P397 is a clear indication that their relationship was not, in fact, a legitimate business relationship, but rather one based on corruption, as P397 alleges. Similarly, the accused's developing story regarding his relationship with Yabe is even more transparently false in my submission. Time prevents me from recounting the evolution of his story, from categorically denying having heard the name Yabe, to admitting that he knew him as an ICC witness, and finally conceding that Yabe had been to his office on several occasions while maintaining that he merely accompanied Gicheru's client P15 for no apparent reason. He then also recalled that he had in fact been interviewed by the Kenyan police concerning the disappearance of this person, a fact I imagine would have been hard not to remember. In weighing whether it is reasonably possible that the accused was falsely implicated by the witnesses, or whether he was indeed involved in a corrupt relationship with them, in concert with his common plan associates, his lies about his relationship with a corrupted witness and an alleged intermediary weigh heavily in favor of the latter, Your Honor. The defense conspiracy theory. My client was framed. The defense asks the court to accept as a reasonable possibility that his client was framed by 8 separate witnesses. But this theory is so riddled with inconsistencies and improbabilities, in the absence of any acceptable evidential basis, it amounts to nothing more than fanciful speculation and wishful thinking. Firstly, the evidence of 8 prosecution witnesses implicating the accused and his associates is too voluminous and too consistent for this to have been a coincidence, in the sense that these witnesses independently decided to falsely incriminate the same person or persons. No, if the accused were framed, this could only have been the product of a grand conspiracy. This conspiracy would require at least 7 of the 8 prosecution witnesses who implicated the accused, all but P738, to not have not only communicated but agreed amongst each other to falsify evidence of witness interference and to falsely implicate the accused, as well as various members of his common plan, such as Samatwo, Mayo, Busane, and various common plan intermediaries. They must have compared notes and agreed to replicate the same modus operandi in their accounts. And they must have persisted with this conspiracy over a period spanning 9 years and while located in different countries in East Africa and later the world. The defense fails to provide any credible explanation as to why the accused would have been selected as the target for the alleged conspiracy. None of the witnesses testify to having any prior dealings or relationships with Mr. Gicheru, or any reason to hold a grudge against him. Nor has the defense presented or identified any evidence to this effect, with the exception of the evidence of the accused's unsworn and evolving self-serving claim that P397 was a client in a land transaction, which I've just mentioned. The only reason put forward by the defense was the fact that the accused had represented P15 in his withdrawal as a prosecution witness. But this remains entirely speculative. I observe that a more obvious target would have been one of the counsel directly involved in the Ruto and Sang case. Secondly, the alleged purpose of this grand conspiracy, namely to obtain benefits and relocation out of Africa to a first world country, quote unquote, does not stand up to scrutiny. To start with, the defense narrative is based on a false and frankly insulting assumption that every African wants nothing more than to leave Africa and move to Europe or America or some other developed country. And the alleged benefits of entering a witness protection program are exaggerated, while the costs, financial, social, and emotional, are ignored. As regards the benefits, it is significant that while the schedules of OTP witness expenses were disclosed for each of the prosecution witnesses, only one was used in cross-examination and tendered into evidence, that for P613. This then is the high-water mark of evidence of the alleged benefits that supposedly prompted this conspiracy. But the schedule of benefits for P613 reveals that, apart from covering her upkeep and necessary expenses, including her children's school fees, she benefited to the tune of $30 a month, or less than $1 a day, a paltry sum to commit perjury for. Although we know that most of the witnesses were subsequently admitted into witness protection by the VWU, the independent unit of the registry responsible for the protection of both prosecution and defense witnesses, apart from this one benefit schedule, there is actually no evidence on record that the witnesses have in fact benefited, apart from the condescending assumption that if they are outside of Africa, they must necessarily be better off. And the defense ignores the costs of relocation, the costs of the witnesses. Witnesses who were relocated and accepted into the witness protection program had to give up their careers, their sources of income, and were totally dependent on the court for their very existence, including accommodation, food, and education for their children. I pause to add that none of these witnesses were previously indigent or uneducated. All had jobs and were able to provide for themselves and their families prior to becoming OTP witnesses. They were then removed from their extended families and communities and moved to strange countries where they sometimes did not speak the language and had absolutely no support network. The Chamber has heard evidence on how several of these witnesses struggled to adapt and how language and education issues were problematic. The travails of P274 and P739 were particularly harrowing to hear. But P516, P738, P613, and P800 all experienced difficulties too. Naturally, they cried out for better conditions, and they cannot be faulted for doing so. However, despite all of this, the defense would have the Chamber accept as a reasonable possibility that the expectation of benefits and relocation was sufficient to prompt these witnesses to conspire to falsely implicate the accused. Despite having experienced the realities of witness protection and relocation, and despite having nothing further to gain in most cases, the witnesses still came to court and continued to propagate the supposed false narrative under oath. Thirdly, this theory disregards the real and present security risks faced by prosecution witnesses in this case, in this situation. These were not just imagined. Testifying at the ICC in the Kenya situation carried real danger, and witness protection was a necessity, not a luxury. As already alluded to, the prosecution witnesses within Kenya faced intense and unyielding pressure and intimidation, in some cases actual violence, sometimes with fatal consequences. The evidence of witness interference from witnesses in this case is but a fraction of the reported incidents of witness interference in the Ruto and Sang case, as outlined in the DCC. This is also a matter of record, Your Honour, as is apparent from Trial Chamber 5A's decision to terminate the Ruto and Sang trial without prejudice. Quote, due to a troubling incidence of witness interference and intolerable political meddling that was reasonably likely to intimidate witnesses, unquote. The defense's attempts to whitewash the phenomenon of witness interference as an invention of the unscrupulous witnesses to get into witness protection simply cannot stand in the face of overwhelming evidence to the contrary. Finally, and most implausibly, Your Honour, the conspiracy must also have involved the various intermediaries whose attempts to corruptly influence the witnesses were captured verbatim in the OPC recordings. This is the only explanation that the defense has for these recordings. But for this to be true, the intermediaries must have knowingly agreed to being recorded offering bribes to witnesses, actions which would clearly be illegal in Kenya as they are before this court. And having done so, Barasa and P495 then traveled to neighboring countries, placing themselves at risk of arrest to meet with P800 and P613 respectively. Why then would they agree to cooperate? What was in it for them? In the case of Yabe, Bet, and Barasa, only an arrest warrant. Turning to the criticisms of the prosecution's investigation, the defense attempts to shift the Chamber's focus from the evidence to perceived shortcomings in the prosecution's investigation. The prosecution called P730 to explain why certain investigative avenues were pursued and why others could not be due to the significant cooperation and security obstacles to operating in Kenya, particularly in the Rift Valley. The defense had the opportunity to cross-examine him, but his evidence stands undisturbed, nor did the defense lead any evidence to the contrary. However, Your Honour, these criticisms merely deflect from the cogent and consistent evidence the prosecution did collect and present to the Chamber. The defense complains that the prosecution did not visit the crime scenes, which it perceives to be the Rift Valley, However, Your Honour, many of these crimes took place not only in the Rift Valley, but at many locations across the region. So, for instance, investigators were present observing Barassa corruptly influencing one witness and P495 corruptly influencing another. Your Honour, I will skip a little bit of that because it's of less importance. The defence criticises the prosecution for failing to call or interview certain witnesses. The defence complains, amongst others, that the prosecution failed to call each investigator so that they could be confronted by the defence, and the OTP did not interview each and every one of the managers and intermediaries of the common plan. However, the prosecution is not required to interview every alleged conspirator or to call every person involved in the investigation just so that the defence can cross-examine them. While an accused has a right to confront all witnesses against him or her, this does not extend to a right to insist that the prosecution calls a certain witness just so they might be confronted. I also note that the defence has had the prosecution's witness list since November 2021, and if they considered that the accused's fair trial rights were breached by the failure to call certain witnesses, this should have been raised at the appropriate time so that the Chamber could rule upon it. The defence, of course, has the right to investigate their theories themselves and to call their own witnesses, including prosecution witnesses, if necessary. They can also ask the Chamber to call witnesses under Article 64(6)(d). Having elected not to do so, the defence cannot now complain that their evidence is not before the Chamber or speculate as to what it might have revealed. The defence criticises the prosecution's witness interviews and preparation sessions, hinting at prosecutorial misconduct while establishing none. These criticisms are unfounded and in any event irrelevant to the assessment of evidence. As regards the witness preparation sessions, the defence complains of improper coaching by the prosecution. But witness preparation was conducted strictly according to the relevant protocols. Should the defence have had grounds to doubt this, then they should have followed the remedies provided in the protocol at the relevant time. These include requesting copies of the video recordings of such sessions, if there were grounds to suspect any misconduct. The prosecution observes that, in fact, on 2 occasions, the defence did request such recordings, both of which were granted by the Chamber. Significantly, however, the defence failed to identify any improper conduct that was revealed in these recorded sessions. Yet they now speculate about impermissible coaching by the prosecution in other witness preparation sessions for which they did not even request the recordings. The defence also complains about the duration of certain witness preparation sessions, but misrepresents the facts. So, for instance, the defence claims that the prosecution proofed, quote unquote, P516, quote, for 7 days for a period of 43 hours and 15 minutes, during which 48 documents were shown to him, unquote. While the total number of hours is correct, the defence omits to mention that the vast majority of the time was spent by the witness reading his prior statements and testimony in both the Ruto and Sang case and the present matter, as the witness preparation protocol requires. The protocol specifies that, quote, during the preparation sessions, the questioning lawyer must provide the witness with an opportunity to review his or her prior statements, unquote. And of the 48 documents shown to the witness, 43 comprised copies and transcripts of his own prior statements and annexes thereto. Regarding allegations that prosecution improperly invited witnesses to expand upon their statements, the protocol requires that questioning lawyer must, quote, provide the witness with an opportunity to confirm whether his or her prior statements are accurate and to explain any changes as necessary, unquote. It also permits the questioning lawyer to review statements together with the witnesses and question the witnesses on inconsistencies in his prior statement. to explain in general terms the topic that the calling party intends to cover in examination in chief, and to explain in general and neutral terms that the witness may be questioned by counsel of the non-calling party on certain matters in his or her statement. And finally, to show the witness potential exhibits, regardless of whether or not the witness has previously seen them, and ask him or her to comment on them for the purpose of ascertaining whether the witness can usefully comment on them during testimony, unquote. The defense does not explain how any of the prosecution's conduct contravenes or exceeds what is required or permitted by the protocol. Rather, their complaint appears to concern the protocol itself, notwithstanding that they did not object to this at the time. Yeah. I'll move on, Your Honor, to the final topic, which is the defense's submissions on the modes of liability. The defense criticizes the prosecution's submissions on the mode of liability with respect to the actions of certain associates, but this criticism is misconceived and based on a misapprehension of the court's jurisprudence. I refer to paragraphs 167 to 186 of the defense brief. The defense claims that the prosecution, quote, misleads the trial chamber into overreaching and exceeding the scope of the charges, unquote. Not so. The prosecution's primary position is that the associates are co-perpetrators, the relevant associates being discussed, and that their contributions were essential even if, with the exception of P800, they intervened only with respect to one incident. As the appeals chamber has confirmed, a co-perpetrator need not, quote, make an intentional contribution to each of the specific crimes that were committed on the basis of the common plan, unquote, provided that those criminal incidents occur, quote, within the framework of a criminal common plan to which the co-perpetrator made an essential element with intent and knowledge, unquote. In this case, the prosecution submits that the pretrial chamber erred in finding that because the associates, except P800, each intervened only once to contact and persuade one witness to meet Gicheru or to withdraw as prosecution witnesses, they did not make an essential contribution to the furtherance of the common plan. But the trial chamber is not bound by the PTC's application of the law of co-perpetration to the facts and may draw its own conclusions based on the facts and circumstances as confirmed by the pretrial chamber.
Mr. Steinberg, your time is up.
Yeah.
I'll give you some 2 minutes more to conclude, please.
Thank you, Your Honor. I'll wrap it up in 2 minutes. Just to round off this point then, Your Honor, while the chamber is barred under Article 74(2) of the statute from exceeding the facts and circumstances described in the charges, it may nonetheless, quote, evaluate them differently, unquote. I refer to the Al-Hassan Charges Procedure Decision, paragraphs 46 to 47. And in Ongwen, the pretrial chamber held that, quote, if the defense can raise at trial the matter of proper interpretation of Article 25(3)(c) of the statute, as the trial chamber is not legally bound to follow the chamber's interpretation of the confirmation decision. In the confirmation decision, I beg your pardon. Hence, the associates' actions were confirmed by the PTC and fall within the parameters of the charges, and the chamber may conclude that they are in fact co-perpetrators and that their actions may be attributed to the accused. I will leave that there. Finally, Your Honor, I point out as a housekeeping matter one or two incorrect cross-references in the footnotes, but I don't think I'll need to read that out since I've handed up my reading notes. And if necessary, the prosecution can file a corrigendum of the closing brief. Thank you, Your Honor. Then, unless the chamber has any questions, those are the prosecution's closing submissions.
Thank you very much, Mr. Steinberg. Mr. Canavas, I'll break up for the court will recess for some 5 minutes, and when we come back, we'll listen to your own closing statement. I'll ask members of the public podium to please wait. We shall do just 5 minutes and come back. Thank you very much.
All rise, veuillez vous lever.